This is Paul Turner, the Immigration Barrister at Imperium Chambers. Thank you for tuning in. Please subscribe to my channel, and if you have an immigration problem of any type at all, please get in touch with me and I'll do my best to help you. Today we're going to be talking about some important changes to the immigration rules which have come into effect. In fact, they came into effect on the 20th of June 2022 without any real notice. Back in March, the Home Office did announce that it was going to be making changes to the immigration rules. As to exactly what they were, we weren't sure. We have covered some of these proposed changes in different videos, but I think it would be helpful to give a summary of these changes, as in particular some of them came into effect, as I've mentioned, on the 20th of June 2022. So they just slipped them in, as it were. To avoid boring you, rather than going through all the relevant changes, I'm going to break down what are arguably some of the most important changes to the immigration rules since the Immigration Act of 1971. Today I'm going to be talking about something which affects a lot of people, which is changes to the private family life route, as these are applications that I deal with on a regular basis. In particular, I'm going to be focusing on the private life route, because that affects an awful lot of clients. At the outset, I'd like to note that applications made after the 20th of June will be considered under the new rules, but if you made an application before the 20th of June 2022, you will still be considered under the old rules. So there's going to be some confusion there, no doubt. The new rules have replaced paragraph 276 ADE to 276 DH. 276 ADE1 contain many of the provisions that you used to rely on quite frequently in chambers, and these included for example, the 20-year route, which allowed anyone that had managed to live in the United Kingdom for 20 years, either lawfully or unlawfully, to be granted limited leave to remain. The 7-year route for children. This allowed anyone who was under the age of 18 and lived in the United Kingdom for 7 years continuously to get leave to remain if it was not unreasonable for them to leave the United Kingdom. The next one was the half-life route for those individuals that were between 18 and 25 and had lived in the United Kingdom for more than half their life. And arguably everyone's favourite, and the area where we struggle in respect of evidence, the very significant obstacles route. This allowed individuals, anyone who's over the 18, to obtain a visa where they could show that there were very significant obstacles to their reintegration into their country. And if they could do that, they would be allowed leave to remain. This was a particularly frustrating rule, as it tends to be very fact sensitive and generally involves a lot of work on our part, as the Home Office is quite fond on saying that people can return home having been here for 12, 13, 14 years to a country where there is poverty. Rather than just keeping the existing rules, the government in its wisdom has decided to maintain the core of them, but has decided to move them into a new appendix of the immigration rules, as if we needed yet another appendix. I was looking at them recently and there must be about 20 of them. This is now called Appendix Private Life. There are, however, a number of significant and important changes in the appendix which do more than just move appendix paragraph 276 ADE into Appendix Private Life. In particular, and this is a good piece of news, children that have lived in the UK for 7 years are now entitled to ILR straight away, rather than just limited leave or having to show that it would be unreasonable to stay here. This is a very welcome change, and we are looking forward to using this particular rule to assist a number of our clients. Children who are not born in the United Kingdom but have lived here for 7 years will be entitled to ILR after 5 years rather than 10 years, in another welcome change. So there is some benefits to children. Other changes include an amendment where children born in the UK to people on the private life route can become dependents on their parents' visas, which again is a welcome change. The previous provisions for indefinite leave to remain under paragraph 276 have also been moved over. And essentially they just have different letters as opposed to numbers. Whilst the additions to the immigration rules are welcome in respect of children, it is a bit tiresome that they've been removed over to a new appendix with a new set of rule numbers and provisions for everyone to learn. It is hardly the simplification that we've been repeatedly promised, and indeed goes against what one of the Court of Appeal judges, which is scrap the immigration rules and rewrite them in an intelligible manner. So therefore it is clear that there have been some significant changes that have been announced in respect of private life that will apply to people that apply after the 20th of June 2022, and they are going to be covered by appendix private life, as opposed to people that have outstanding applications who will be considered under the old rules, paragraph 276 ADE, etc. So if you have or are considering making an application, it is worth noting that the rules have significantly changed. If you wish any advice or any information, or you want to make an application under the private life, and in particular if you have children, things have moved directly in the applicant's favour, then do get in touch with me and I'll do my level best to help you. Again, there will be more videos on further changes that have been announced, but rather than bore you to death with the various appendices and changes in one video, I'll be doing a succession of other videos. Thank you very much for watching. Do stay safe and do take care. Thank you again. This is Paul Turner, the Immigration Barrister at Imperium Chambers.